We first of all, in terms of gathering data on for the purposes of the process evaluation, we needed to first of all describe who were the kids who appeared before the court, and these were derived from the Children's Court database itself, as well as the files that were held on each of the defendants. The data on the implementation or operation of the court was derived from observation. Data on the court actor's experience was derived from interview, with the exception of families and the defendants themselves. And data on court improvements, what might be done to make for a better children's Koori court, were derived from observations, extensive and time-consuming observations of the hearings, and interviews with the court actors and some of the external stakeholders. What about the kids? The study population was 72, but I have the number, it was 62, I beg your pardon, but I have the number 72. The study population was only those kids who appeared before the court, had their cases finalised, and whom we could track for at least 6 months and up to 2.5 years. But there were an additional 10 kids who appeared, whom we included in terms of just describing the population, but we weren't. But they were the kids who appeared most recently, and therefore did not meet that minimum 6-month tracking period. So I've just thrown them in here for the purposes of giving you some sense, some rough sense of the cohort who we tracked. These are the 10 who are not applicable because of that 6-month period. But as you can see, the numbers that were tracked for varying periods of time varied somewhat. This gives you some rough sense of their age, and it's interesting, to me at least, there was a good number of 18, 19-year-olds appeared. These were mainly kids who might have offended while minors under Victoria's law, but by the time the cases got to court, they were 18, so the case might have started when they were 18, and it could have even continued and spilled over into their 19th birthday. But this gives you some sense of the age at which they were when they first appeared at the Children's Koori Court. With regard to prior offending history, there was only 18% of them who had no prior offending history. A whole bunch of them had received cautions or had been otherwise diverted by the court. There were a further 10% who had prior offences proven in the Children's Court, but without a history. In other words, they had never been cautioned, they'd gone straight to court, and we had a third of them who had both had offences proven and had also been diverted previously somewhere along the way. Overall, most of them had had some involvement with the juvenile justice system, and as we will see later, some of the prior offences were really quite serious. This is what happened to them when they went to the Children's Koori Court. We had about 15% of them had either charges dismissed or got no more than accountable undertaking. Good behaviour bonds were very popular, a third of the kids. In terms of supervision orders, which would have taken them into the Department of Human Services responsible for these orders, it was about a third of the kids. Only 10% of them ended up in detention of some form or another. One case was adjourned, it went back to an adversarial court. There was only one case where, and we'll see this later on, where the defendant failed to appear. You've got to remember that the kids themselves, when they come out of a mainstream children's court and are found guilty, they are not forced to go to a Children's Koori Court for sentencing. They opt to do that. They might be advised to do that as being a good thing to do, but they are not forced. And of all the kids who opted to go to the Children's Koori Court for sentencing, only one can turn up. That person was subsequently, an arrest warrant was issued, and they ended up at the Children's Koori Court anyhow, but not voluntarily. And this was an initial appearance that was adjourned. It's not uncommon for cases to be adjourned to get further reports and advice before a sentence is imposed. So when by the time we finished data collection, there were still 6 cases that were still in train, where there had been an adjournment. A lot of the kids had some prior involvement with the Department of Human Services. They might have been under previous supervision orders and hence have a Department of Human Services Youth Justice history. There were a whole bunch of kids who were under child protection orders or had been, and there were a small handful of kids who were disability services clients. And we often sense that when in the course of the hearings, when it was rather difficult for some of these kids to actually engage with the elders and the magistrates, that there were probably possibly some cognitive and other disabilities at play. But so there were a number of those. Now, of the 72 who appeared before the Children's Koori Court during its first 30 months, only 62 of whom we actually focused upon later on. They were overwhelmingly male. The boys were just over 16, the girls were just under 16. We had some older ones, as I mentioned as well. They were mostly, 80% of them came from the designated catchment area. There were 20% who came out of the designated catchment area. Of the study population for whom data were on prior offending history were collected, 62 out of that 72. 73% had been formally cautioned, 40% had one or more prior offences proven at a previous children's court hearing, and that about over 3/4 of them had an established history of offending, ranging from minor to, as we'll see, some pretty serious stuff as well. They had committed a wide range of offences. I've already reviewed the dispositions. There was often a considerable time lag between the commission of the offences and the kids appearing before the Children's Koori Court. That is not unique to the Children's Koori Court. It happens quite often that it can be months or sometimes years before someone is picked up for an offence and appears before court. And many of the kids were already known to the Department of Human Services, either as current or past clients. What did we find in terms of these dimensions? Failure to appear. There were actually 7 failure to appears, which is at odds with what I can't quite get my head around why. But there were 7 kids who failed to appear. Most of them during the first 6 months of the operation of the court. Now that might possibly be explained by the fact that the court was new and perhaps unknown to anybody outside of the people involved in the court. But as time went on, there was only 1 failure to appear in the next 6-month period, and later on there were no failure to appears. We then looked for some comparative data on failure to appear rates and couldn't come up with any. So we turned to our research advisory committee and said to them, well, what do you make of this failure to appear rate? And I think from my point of view, it was a very modest failure to appear rate. And the advisory committee, which was made up of a whole bunch of people working in Koori, adult and juvenile justice and academia and so forth, they were all of the view that this was quite a modest and therefore quite a good sign that the failure to appear rate was so low.